Hello everybody and welcome to our special panel on how producers can protect their legal rights when it comes to biosecurity, brought to you by our partners at Rees and Sydney Jones. We're going to talk all today about how you can look after yourself and make sure you know your legal rights when it comes to the big issues like protecting yourself against contractors coming onto your property, which of course is happening more and more with the rise of these renewable projects, for instance, and sort of mining leases, etc. So we've got a great panel here today to talk us through what your rights are, both from the legal perspective and from the producer perspective, starting with Melanie Findlay, who's the Managing Partner of Rees and Sydney Jones, Elyse Riethmuller, who is the Chief Executive Officer of the Fitzroy Basin Association, Brigid Price, the producer from Price Cattle Company, and Matthew Dunlop, who's a solicitor at Rees and Sydney Jones. Thanks for joining us today.
Thanks for having us.
Great to have you here. So, Melanie, let's start with you, I guess. There's been an explosion in renewable energy projects in rural areas, but they all require contractors to come onto your property. There's machinery coming on, all kinds of visitors. They can bring in invasive species or even pathogens onto the land. What are some of the risks that landholders are facing in this space?
I guess opposed to normal gas and mining exploration or contractors, there is no law. So when it comes to renewable energy companies, it's just a contract between you and the company that wants to access your property. So there's no government intervention, there's no Department of Environment or anything involved. The law just hasn't quite caught up in that space. It will catch up one day, but right now there is no rules.
Right, no rules. But so, Elyse, this is probably a concern for you as CEO of the Fitzroy Basin. The natural assets there you spend a lot of time thinking about and caring about. What are your concerns here?
So landholders obviously are managing a large percentage of the Fitzroy and they want to manage that land from a production perspective. We've also got some amazing natural assets in that landscape that we also want to protect and enhance. So how do we help and support landholders to undertake those functions in a way that is cost effective?
So you're doing a lot of work, obviously, on looking after those assets, and then somebody comes on to your property. So just talk about those issues that you've already seen, and then what about some of the financial impacts that's likely to have?
Okay, so the challenge is with weeds. We've got a weed load everywhere, but certainly you want to be able to manage that, and you don't want anyone bringing on more weed seed onto your place because that's an extra workload. It's an extra cost to a production system that you don't need. And then for some of our special places like koala habitat, when you have things like lantana, it's very difficult to actually control that lantana. It's an annoying weed to control, and from a koala perspective, it's really hard to actually get up the trees, so they choose different trees. Yeah.
And Brigid, as an organic producer, I imagine weeds are a real problem for you, of course, because you haven't got the same tools to deal with them.
Absolutely. If we got an incursion, we are very limited. So it's really important from our perspective to put those mechanisms in place to identify those risks and to ensure that biosecurity management plan and your processes work. But that's the reality. But even across other properties, the main thing is weeds aren't necessarily just those ones that are on a registered list, which the government is more likely to step in. There's also weeds that really impact your productivity and also animal health.
Yeah, and have you already had an issue with this in terms of how you've had to deal with it in the past and whether it's cost you?
Absolutely. So from our perspective, we have got third-party contractors from an established industry, so I think there's lessons to learn because we have coal seam gas. And so we really tried to think of what are the worst case scenarios. So we put quarantine areas in where vehicles had to come in. The problem was in those quarantine areas, they were bringing vehicles in. They were then housing the quarantine vehicles in those areas. And so our worst nightmare of those seeds being carried through the property and then actually onto other properties has happened to us. So it's definitely a reason why the producers do have issues and have concerns and have every right to have those concerns.
So Matthew, this is where it comes, I guess, to that legal understanding and that legal help. So, obviously the best way to prevent these from occurring is to be prepared in the first place. How aware are farmers of their rights in this instance?
It's a good question, and I think all of the graziers I've dealt with over the last few years are aware of their obligations, but not necessarily what they need to do to comply with them. To break that down, what I mean is they're aware that there are biosecurity obligations, but may not necessarily have a biosecurity management plan in place, or one that is sufficient or meets the legal requirements. And that's where they get themselves into precarious situations when they have people wanting to come onto their property.
So they're obligations, but I guess the question is, Melanie, rights. What rights do farmers have?
So contractual rights for a start. So with renewables, that's all they have. So we have to write into the agreements the rules that they want the companies to comply with. So if they want a third-party washdown certificate, if they want to enter into a certain section of the property, sign in a QR code, staying on certain tracks and that kind of thing, rather than letting them go all over the property, we've got to write those words in. When it comes to gas and mining, there's a different layer in that there is the environmental rules that the companies have to comply with, but in our experience, they're insufficient.
Yeah.
So the idea of rehab to a landholder is very different to rehab to a Department of Environment, for example. So it's got to be the words and the contract.
I think it's also important to say in 2016, the government changed. We changed from a Land Protection Act to the Biosecurity Act. The Biosecurity Act is a watered down version, and also there are certain industries, so in our case we have an active biosecurity management plan in place. It is not an offence for those mining companies not to comply because they operate under a different set of rules. So a lot of people think if you have a sign at the gate, if you have a scan-in code, then you've got that and you're protected. So it was really important for us to have the legal team that knew we actually have to have a stipulation in our conduct and compensation agreement that says you must abide with that biosecurity management plan. Because the problem is, and as we've learned, when they don't abide by it, we now have to take them to land court. It's the only recourse that we have. So getting that conduct and knowing your rights and really being vigilant from the start as to what the impact on your business could be is really important.
Yeah, right. And Elyse, I guess it's where it comes in. What do you need to sort of enforce upon people in terms of best practice, and then how can you do that?
I think it comes back to actually helping a landholder to understand their rights and also to be confident to communicate those and set the expectations of both companies and individuals entering the property. That becomes really important, and I can see with a lot of the landholders we deal with, it doesn't come naturally to actually have to push that and ask for that information. So.
Sorry, because if you think in the chicken industry or poultry, you would know if you're visiting a farm, there are strict measures and there are everything. Beef, it's a little bit different, and because we're really, we're welcoming, we're interested, and we actually expect people to be respectful and mindful, and if those rules are there. So the difference is we have to not only have a biosecurity management plan to be able to sell our cattle under the LPA requirements, but we also have to own it, we have to be vigilant, and we have to be willing to upgrade it. So we had an app, and I think in the hundreds and hundreds of visits in the 12 months that we trialled the first app, there were 79 uses of that app, and one was by one lady. So it's even getting compliance where in COVID people could do it if they wanted to step into this shop or that shop, but really it's about taking that really proactive response and not assuming just because you have one that other people. We are dealing with shareholders, we're dealing with contractors, and we ourselves are stakeholders. So it's a very different expectation and timeline of implications.
Yeah.
There's probably also the flip side of that is also helping landholders to articulate to the companies that are coming on the impact that those weeds or pathogens could have, so that you actually get that buy-in from somebody to actually want to help them comply.
And that's a communication thing, but Matthew, I guess it's the contract as well. If you have a contract and you have that in front of somebody, say, this is my contract, here are the rules. How hard is it to get that and to get granular enough in that so that you can present it to somebody so that that can cause them to act in the right way?
Look, it can be difficult for landholders to get a level of detail in those contracts that's sufficient to protect their biosecurity interests. But at the same time, they appreciate that it is necessary. As the other panellists have spoken to already, there may be an environmental authority in place, but that may simply say they must adhere to biosecurity measures, full stop. Whereas a particular property may be used, say, for an organic activity, which requires a lot higher of a standard in operation in biosecurity, or there might be a specific biosecurity risk on a property. Those need more stringent protections than a stock standard environmental authority. So in my experience, there is always a discussion around the commercial and practical nature about adhering to a requirement, such as going to a third-party washdown facility and getting that certificate. And each landholder has their own level of risk when it comes to getting that third-party certificate or a driver-completed declaration. But those discussions do have to be had. As Elyse mentioned, in my experience, when you do explain to the resource company the need for those protections, that does help them understand why they're required. At least in my experience, thankfully that's come about.
And Brigid talked about an app just for a second. I mean, can you get as granular as people who don't use the app are therefore not compliant with my contract?
That's right, and Brigid can probably go into more detail about this, but the apps I'm familiar with, you can have, say, a QR code on the fence, and when you scan the QR code as the driver, it'll take you to a web page with all of the biosecurity requirements in place, and you tick the box and say, I agree to comply. Legally speaking, that's a binding contract, and so if there's a breach, then you've got recourse there.
Now, Melanie, Brigid did talk about how open and generous, cattle farmers are. But you're talking to people who maybe don't understand your industry at all, right?
Yeah.
They're contractors coming from Sydney or Melbourne or who knows. They don't think about the impact of what they're doing. So let's role play for a second here. And this is obviously what lawyers do every single day. If you go to court, for instance, you have to really give a strong argument. How should landholders talk to contractors so that they can properly communicate and be firm and be strong to not kind of go, oh, okay, well, I don't want to cause a fuss or whatever?
Well, I normally sit down with a client and ask them about their biosecurity concerns, and maybe there's already an incursion on the property. So we normally do some mapping with them, and then we normally advise them of their rights, ask them to fix up the biosecurity plan and chuck it on the back. Funny story, Thursday, was talking about GRT with a client on Zoom, 3 clients, and one client said, I've got GRT, I'm really worried about this renewable company coming on my property and spreading it around. And I said, all right, well, we'll get a map and we'll mark the area and we'll say that they're not allowed to go there. And then I said, we'll make sure we do your property last. So we'll do the clean properties first and we'll put that in the contract. And then all 3 clients put their hand up and said, we've all got GRT. And I was like, okay, so we'll just have to mark it on the map and then they're not allowed to go there. And then all 3 clients said, but it's everywhere. And it was like, okay, well, how do you protect against that? So, most of our phones, when you put the location services on, you can take photographs of the areas and they'll give you a GPS point and that kind of thing. So if there is an incursion and there is a breach and you think it's from the company, you can help set a baseline and have some proof. We can sometimes even write into the documents that a baseline assessment is done as well. So if things go bad, and I always say to the client, you might get along with this contractor, but they always buy and sell as well. So you might be dealing with a baddie in the future. So you've got to plan for the worst.
Yeah, but I guess you can't monitor every single entry point on your property all the time,
No.
right? But I guess let's say that someone is coming in the front gate and you have to walk up to them and say, stop. Just give us how you should have that conversation. What's the best way to approach it?
Well, you'd say, oh, hi, you need to sign in. I've got my sign-in scan-in up here. And then you'd normally check the vehicle over because, Parthenium seeds can sit in the grill of a car for 10 years, for example. So, and if the car is dirty or you find mud behind the mud flaps or whatever, you can ask them to leave. So, but you need the document to say that. I've seen a lot of documents that let companies go all over the land, not stay on singular tracks, because it's easier to prove problems if they've been required to stay on small areas. We need to make sure that there is that requirement to sign in when they come and go. Yeah.
And after the fact, what can you do?
If it's a gas mining company, Environmental Authority and DES is the cheapest, but they'll take about 2 years to come out and have a look at everything. Sometimes you've got the land court avenue. With renewables, it's just contractual breach. So it's court mediation.
Wow. Okay. Brigid, have you had an experience of this where you've tried to seek recourse?
Yes, so in our case, I've been to the Gasfields Commission, I've been to the Land Access Ombudsman, I've been to the Department of Environment and Science, I've been to the Resources Hub, the Compliance Hub through Department of Resources, so absolutely I've tried every avenue for recourse.
Tried and succeeded, or tried and you're still going through it?
Tried and we've learned across the way. I got most action out of frustration when I went and wrote a ministerial complaint, and instead of going in at one level, having to go down, and also when I'm quoted one section of the legislation, having lawyers that can say, don't look at section J, look at section 12. But it is currently the onus is on the landholder, and it's not right in that if I want to do recourse, and I've tried all the other avenues, and in our case, if a gas company can say, oh, but we've done that and we do that, the mechanisms weren't there to investigate. It has taken a few years, but now we are getting investigations, and I do have to give those departments credit now, but it is a very long process. And under the Land Access Code, we have only, a lot of this we learnt along the way. You only have 2 years from when you're aware of it for the department to make awareness. And the other thing we learnt along the way is there are aspects where in environmentally strategic cropping land. So it's priority areas, but what happened was when the new act, the environmental acts changed and the regulations changed, if we sign a voluntary agreement, then all of these measures that we wrote in our voluntary agreement, we're excluded from that. So we don't have those avenues of that higher level regulation, and so we're on our own to fight it. So it's not fun.
Matthew, yeah, from a legal standpoint, I mean, how hard is it to get recourse? I mean, we've obviously heard about Brigid's journey. That's one that I guess, are you in that journey as well with someone like Brigid? And
from time to time, yes. And it does depend on the relationship at the time. So most contracts these days, they'll have some sort of dispute resolution clause that can drag the dispute out if there is a solution somewhere in the horizon. And that often means more legal costs. Sometimes the additional time can result in more opportunity to get evidence. But if that fails, then you can go down the land court aspect. Talking in regard to mining and gas, our regime in Queensland requires compensation and conduct agreements to be entered prior to the activities beginning. And so they, as we've already touched on, they can be one avenue to seek legal recourse, in addition to any statutory obligations that may have been breached by the company. But it all costs a lot of money, and it may be years down the track after the activities, which makes it harder and more costly to try and find the evidence to support your claim.
so Elyse, all I'm hearing here is it's much, much better to be on the front foot with this.
Definitely much better to be on the front foot. So when we work with landholders, it's ensuring that your vehicles are clean before you come in, developing that level of respect and trust and relationship with the landholders, and then when we have projects where we are engaging contractors, we actively manage those contractors.
And what about subcontractors?
And subcontractors, to make sure that we're not putting that impost on landholders, because we want to work with the landholders for a long time.
And can you force the original contractors to ensure that the subcontractor is doing the job properly?
Look, we probably go the more path of least resistance and just go in and fix the problem.
For us, we write into the contracts that we are only dealing with gas company XYZ. The client doesn't have to go to the sub. We just deal with the head contractor. Yeah.
Well, it's pretty warm out here at Beef, and we're all feeling like we've put some serious heat and light onto this issue, I'm hoping. But before we go, let's take one big takeaway that everyone should think about as they sort of conclude watching this. What's the one big thing you want them to take away?
Prepare and plan rather than try and fix it later and chase your tail. Yeah.
Don't be afraid to say no. I need to see all of your information and your credentials before you come on.
I think to look at it as you do any other enterprise in your business. So if you're a beef cattle, if you're cropping, do your due diligence, look where costs could be shifted, and really know your own risks to be able to manage them.
I would say be creative regarding the biosecurity measures that you need. This high influx of attendants needing to comply with them. I've had clients require third-party washdown certificates. Mm-hmm. We had a foot and mouth scare a few years back. There were clients requesting boot washdowns or new boots to be worn and proof of which, and some companies agreed to those measures. So don't be afraid to throw ideas out there that you think are unorthodox.
And I would say get some good legal support. Thanks so much for your time today. Thanks Melanie, Elyse, Brigid and Matthew.
Thanks Jackson.
Thank you.